Your Honor. May I approach this as for the court? Also, Your Honor, not to be argued today, crystal clear, I do have a pack of case law and a hard copy of the transcripts of the two witnesses that we've all agreed on for the court, if you'd like those today.
Yes, if you have them already printed out.
I do, and the state's been given a copy of everything.
Okay, thank you.
That's all for the court.
And then you have,
I'm late.
okay, thank you. Yes, sir.
And from the state's perspective, Your Honor, we just want the opportunity to argue about two documents that the state believes is not attorney-client privilege, of which the state has viewed. The rest of those items, the state of Florida has never seen, albeit I understand the defense argument that we had the ability to see them.
And are those documents in the packet I've been given?
Yes.
Okay, well,
The only two, the ones they want to argue about are the only two we give you.
we're not arguing about the documents today.
Correct.
I haven't even seen it.
Correct. And since the defense has submitted case law, I have some case law for Your Honor as well.
And I would be happy to see it.
And I'll give a copy to the defense.
And what I have, the packet you've given me, contains everything that I referenced, that was referenced in Judge Kite's order.
The only, albeit I'll admit, the only thing I provided you, which I thought was the agreement what Judge Kite put in the order, were the two documents that Mr. Mizrahi has mentioned and that were contesting. I thought all of the other 67 emails, that was for, because they've never, the state says they've never seen them, Judge Kite was going to rely on that. You don't have those.
Is that correct?
Well, it's correct, we've never seen them. My understanding of the last hearing was that you were gonna review those to see if they were in fact attorney-client privilege. We believed they were, and that's why we didn't look at them, but we haven't seen them. We have no idea if they're attorney-client privilege or not.
So what do you want me to do?
I would like the court to review those items to see if they are in fact attorney-client privilege. I
The
thought
order
that was-
references some 66 emails. And so my initial prologue in trying to expedite this hearing was to make it clear that I thought I was to receive the confidential communication referenced on page 4 of Exhibit A and the 66 emails, as well as the communication with Mr. Cox, and I'm assuming some record of the telephone call with Mr. Wagley.
That's Ms. Gardner's issue, but I want to be very frank. When Judge Kite asked me at the last hearing, she held up her hand, she said, "The two." I understand what you're saying. If you will give us, by the end of business today, I will give the 67 emails to Mr. Mizrahi completely blacked out, and I will drop off to your office the 67 emails completely unredacted. I do not have that in the packet for you today.
Yes, sir.
I'm sorry.
No. See, judges don't think their orders are subject to interpretations. So let me look. Judge Kite does specifically say confidential communications and emails referred to on page 7. And so that would include all, and if you could do that, the court would appreciate the courtesy.
Done.
Anything else?
Not for this guy.
Nope.
Judge, I have a separate packet for Ms. Gardner.
Oh, okay. And has that been reviewed by everyone?
Well, not the state, Your Honor. I do have an index. I have some paper documents as well as a disc. There are 3 audio files that we found. I'll describe them for the record. One is a recorded phone call with Mr. Cox and Ms. Baraskis, who works for the Dell Law Firm, and then 2 voicemails from Mr. Cox. There's an email string with Mr. Cox, an email string with Mr. Mason, who was a family law attorney at the time, an email from Brett Anderson, who was an estate planning attorney at the time, and then there's a string of text messages between Ms. Gardner and Ms. Baraskis. And so there's a disc, Your Honor, as well as printed out copies of those documents. I did not include the aforementioned recorded call that you mentioned. I can burn that to a disk and get it to you this afternoon, sir.
I would appreciate that.
Yes, sir.
Okay?
How would you like us to deliver those to you and where? Where is more important?
To Ms. Burke?
And I'm on the 7th floor,
Yes,
so
ma'am.
if you can deliver it to the 7th floor,
Yes, ma'am.
that'd be great.
Okay. Yes, sir.
And Your Honor, because the state has indicated they have never seen any of this, I have not shown it to them. I don't know if the court would like direct me to give them a copy of the index after the court reviews it. I don't, especially with the audio files, I don't know that there's a way that I can turn over a redacted copy of them. I surely can redact the emails and black out everything on the emails and text messages if the court wants me to do that.
Well, I think it's quite possible that whatever order is issued by me as special master will delineate each separate item, identify it perhaps by sender and receiver, and then opine whether it is privileged or not. And I would hope that would be sufficient.
That's the key, Your Honor. We need to understand what the court's rulings are.
Okay.
Yes, Your Honor.
Yes, so you're fine,
Yes, Your Honor.
okay?
Thank you.
Anyone else? If not, we are adjourned. Thank you very much. Let me see this second. I hope you remember
I'll see you in about 30 minutes.
I'll be there. Just if you bring it up, the office will call me.
Yes, ma'am. Yes, ma'am.
Thank you.